Hello, everyone, and welcome to today's webinar on proactive and reactive strategies to protect your brand at the border and on the web. My name is Graham Hood, and today I'm joined by my colleague, Tamara Celine Weingust. Before we dive into the content, I'd like to start with a few housekeeping details. Our formal presentation will last about 45 minutes and will be followed by an open and interactive Q&A session where we'll address more specific questions you may have. You're welcome, of course, to submit questions at any time during the presentation by clicking on the Q&A button at the top of your screen. We will try to address as many questions as we can during the live session. This webinar is being recorded. After the session, you will receive an email with a link to the recording along with a PDF copy of the slides. At the end of this webinar, a survey link will pop up. We would appreciate it if you could take a few moments to share your feedback on today's session and let us know what other topics you're interested in learning about in the future. So, who we are. We are Canada's leading IP firm, Smart & Biggar. We've been serving clients for well over a century with expertise in all areas of IP. We are Canada's largest IP firm with more than 180 lawyers, agents, and technical consultants across the country, with offices in Vancouver, Calgary, Waterloo, Toronto, Ottawa, and Montreal. As I mentioned, my name is Graham Hood. I am a principal with the firm's Trademarks Practice Group, having practiced exclusively in the field of trademark law for about 15 years now.
My name is Tamara Celine Weingust. Like Graham, I'm a principal in the Trademarks Group. My practice spans both trademarks and copyright law, and I've been practicing for about 13 years.
We're thrilled to share with you our insights today. Let's proceed with the presentation.
Before we get going, we'd like to set the stage. What problem are we thinking about? What are we talking about when we discuss proactive and reactive strategies to protect your brand at the border and online? So really, it's about controlling the narrative. Your brand is your identity. It creates a mental connection between a sign or a symbol and the character and quality of the goods and services that the business is offering. And the control over that character and quality and the control over the perception of that brand is really important to driving goodwill. If your product is making money or your services are making money, though, however, there is a risk that someone somewhere is probably trying to knock it off. Everyone loves a winner and everyone tries to glom onto them. And recent developments in technology really pour fuel onto the fire. AI makes things discoverable faster, more easily. And so what we're seeing now is brand holders, in trying to control their narratives, are really thinking, what can we do proactively to protect ourselves and position ourselves well? And then what can we do reactively when things go wrong? And that's what Graham and I are here to talk about today.
So I'll start by talking about some proactive strategies that brand owners can utilize to protect their brand, both at the border and on the web. And these proactive strategies really fall into two categories. We have internal consumer mobilization and external government strategies. Internal strategies include in-house training, product authentication, integrating your IP into your launch strategy and strategic watches, and then external government-based strategies, maybe SIPO registrations, CBSA recordals, and enrollment in online programs. We'll talk about each of these in turn. So when it comes to in-house training, probably know that most risks are spotted outside the legal department first. They're spotted by someone in marketing, maybe someone in IT. I think it's important to think of your employees as guardians of your brand. And if you can equip them with an anti-counterfeiting education and strategy, they'll be on the lookout for trademark misuse and counterfeiting in the marketplace. They're shoppers too. And so you can tell your employees to get in touch with legal if they see something suspect in the marketplace. It's important to develop short, practical trainings for your business teams. Educate your employees about what counterfeiting looks like, what trademark misuse looks like, the difference between the two, and when to bring the issue to the attention of your legal team. Because if you get in front of an issue quickly and proactively, it will save you time and money down the road. It's also important to build authentication into your products. And this works in two ways, really. One, it makes your products difficult to copy, and it also educates your consumer about buying the real thing, what to look for to ensure that what they're getting is in fact the genuine article. Some brand owners will use QR codes and serial numbers together with batch codes so that each individual item carries a specific serial number that is unique to that particular product that cannot be copied. Some brand owners use invisible ink on their hang tags or labels, or even inside their products to authenticate their products and be sure that you know you're getting the real thing. Consistent packaging and labeling is also important. You want to ensure that your consumers know what to look for, colors, print, graphics, and that way they can be educated about what the genuine article looks like. Having centralized how to spot an authentic product guidance within your own business will help educate your own employees about what distinguishes the real thing from the fake one.
Graham, if I might interrupt, I would also
Please.
add, I would also add to that, to the extent that the products are being sold through certain channels and not other channels, making the list of those channels or the location of those stores available online and easily accessible to consumers. Because one of the easiest and fastest ways to get ahead of a problem is to let customers know where they can find your product instead of just doing a general search online or clicking on a link that they might see on social media. Knowing what your proper channels of trade are can really help drive the business to the proper channels.
It's an excellent point. A lot of brand owners will feature lists of stockists on their website so they know consumers know where exactly to go to get the genuine article. And that plays into consumer education and reducing consumer confusion. It also assists with strengthening your brand and helping you take action at the border. It also assists with reputational damage. If your genuine article is well known to consumers know what to look for, reputational damage can be limited because there may be less demand for the fake product in the marketplace. It also enhances customer awareness and loyalty. This is a critical component of any proactive plan of attack when it comes to addressing counterfeiting, infringement, piracy. Integrate IP into your go-to-market strategy. It's never too early to start thinking about IP. Before you pick a mark, launch a brand, don't assume that the coast is clear. Take a look at what's already on the register, what's already in the marketplace, and clear your trademark before the product launches. This is a classic case of an ounce of prevention is worth a pound of cure. And brand owners, marketing, legal departments are encouraged to work closely together to align on strategy and timing. Occasionally, we find that we're called up at the last minute to clear a mark on the eve of a launch because the right hand didn't know what it was doing. Marketing had plans for a product launch, and legal simply wasn't aware of it. So if you can get ahead of it and align on timing, it makes things easier for everyone, and it helps avoid unnecessary costs of rebranding or removing product from shelf if the product launch turns out to be infringing. Strategic watches are another tool in your toolkit of proactive strategies that you can use to combat counterfeiting. Planning ahead avoids the unnecessary pressures of taking swift action at a deadline. So We encourage brand owners to schedule regular scans of social media, use AI-powered tools like Canada's own Halu to monitor trademark registers in real time, utilize your own team members from all departments to monitor the marketplace as they're shoppers too, and ask outside counsel to monitor potentially problematic filings for opposition. I find that the sooner you can get ahead of something like this, the more time you have to strategize, to think clearly about what it is that you want to do, what it is that you want to accomplish. And we found that if you're aware of a filing just having been made that you consider problematic, it's sometimes best to take action right then and there. Don't wait until it's published for advertisement. Sometimes a third-party applicant will be more inclined to abandon their application early, to abandon their brand before they start using it shortly after filing. The longer you wait, remember, the more opportunity the applicant has to build their own brand awareness in the marketplace, the more resources they spend on their own brand, and the more entrenched they become in their position. Now, this one's simple, it's straightforward, but it's very, very important. Register, register, register. We encourage brand owners, clients to register their marks with the Trademarks Office. It unlocks rights, including additional causes of action. It allows you to record those rights with the border or online through various brand registries. And it's a very effective sword and shield that can be wielded against competitors in the marketplace. I find it's the biggest bang for your buck. Provided that you have a strong, distinctive brand, exclusive rights are relatively inexpensive. And now that the Trademarks Office is back on top of its backlog, I guess, it now takes no more than 8 months from filing to examination, whereas it previously took over 4 years. So provided the coast is clear, provided that your application sails smoothly through the Trademarks Office, you can obtain a registration in less than 2 years. I want to talk a bit about online brand registries. I think these are important tools for brand owners that can be used strategically for those brand owners that commercialize products on online marketplaces like Amazon, like Alibaba. With respect to these brand registries, what they do is they offer rights holders tools to monitor and police these online marketplaces. They'll provide registered brand owners with alerts when someone tries to post a product detail page featuring their trademark, and it allows these brand owners to actively police the marketplace themselves by flagging and tagging for review suspicious product detail pages created by other unrelated third parties. Amazon Brand Registry is one example of an online brand registry that can assist brand owners. Amazon Brand Registry requires a trademark and a brand name or logo affixed to your products or packaging. Previously, you needed a registration. Now, ABR accepts pending applications, and it can assist with listing creation and management in that if you're registered with ABR, there are only 3 types of sellers that can create a product detail page: the brand owner themselves, sellers that are internal to the brand owner, and authorized resellers with the permission of the brand owner. So anyone else who comes along who tries to sell one of your products through its own online store on Amazon will be flagged and prohibited from posting. It also allows brand owners to enjoy additional layers of protection like machine learning and detection technology. And so with each correct report, the program in fact gets smarter and is able to identify suspicious postings well before they in fact go live. The Alibaba International IP Protection Program is yet another online brand registry that can assist brand owners. This one is slightly different in that it requires IP registration to enroll. You need a trademark registration. You need a patent registration, a design registration. They will accept both registered and unregistered copyright in some instances, but generally speaking, you need to have a valid certificate in hand before you can take advantage of the program. It allows brand owners to quickly submit takedown requests through the platform and to submit DMCA, or Digital Millennium Copyright Act, notices to combat copyright infringement in certain cases. If you're a patent owner and you've noticed potential patent infringement on the Alibaba platform, you'll need to submit an analysis report, essentially a layman's summary of your patent and its claims, in addition to your takedown request, in order to have them take action. Border recordals are a relatively new tool that can also be wielded against counterfeiters and infringers at the border. So the Request for Assistance program was launched in 2019 with the help of the CBSA, the Canada Border Services Agency, and there are now over 600 RFAs on file. This program allows brand owners, rights holders, to record their rights with Canada Customs, which will be on the lookout for any incoming or outgoing or in-transit shipments that may contain suspected counterfeit goods. I practiced in this area for several years now, and one thing I've learned is that counterfeiting is industry agnostic. As Tamara mentioned at the top of the webinar, if the genuine article is making money, chances are someone somewhere is trying to knock it off. So we've seen everything from counterfeit tires to toothbrushes, consumer packaged goods, clothing handbags, of course, also consumer electronics, household cleaning products. The list goes on. No, it's no longer a problem that's exclusive to luxury brand owners. So one thing we tell clients is that, even if counterfeiting is not at the top of your list of concerns, a request for assistance is a really cost-effective way of gathering information, learning what's coming into the country. You can record your rights. It's a matter of minutes. The CBSA is very quick at entering rights recordals. You'll receive a confirmation within a day or two. And then for the next 2 years, while that RFA is valid, the CBSA will be on the lookout for anything that looks suspicious. And if they come across something that, doesn't look quite right, they'll give you a call. They'll give your representative a call, and then you can take action against the importer while the CBSA detains the goods. So in order to do that, in order to record your rights at the border, you need a few things. You need a registered trademark. You need to provide the rights holder's name and address. Copyright protected works do not need to be registered. You can register or record both registered and unregistered copyright protected works. And you can now also record GIs, or geographical indications, with CBSA. You'll also need to provide the information of a contact person like outside counsel who can take the call when the CBSA detects something suspicious crossing the border. In addition, it's optional but recommended, you can provide a list of known authorized importers, a whitelist that the CBSA will enter into its system so they know that goods going to or coming from these particular parties are all good, and then a list of known distributors of illegitimate or suspect goods that they can keep an eye out for and flag if they see anything coming into the country from those locations. In addition, you can provide training materials for the CBSA, including product identification guides, anti-counterfeiting guides, even tutorial videos on how to properly identify genuine articles. All of this is housed in the CBSA archive, where border officers have ready access to all this information and can take a quick look to see whether or not something that doesn't quite pass the smell test is in fact genuine or fake. As I mentioned, RFAs are valid for 2 years. They're amendable and renewable indefinitely. You can have them on file for as long as you're using your mark.
And Graham, just to touch back on the optional information to provide, CBSA does keep all of this information confidential. They treat it as highly confidential. When the system came in about 11 years ago now, it was 2015, a lot of rights holders at the time were concerned about how their training materials would be treated, given how sensitive a lot of the information is, how proprietary a lot of the information is. And I'm pleased to say that over the last 11 years working with CBSA, they understand the mission. They understand how important it is to keep these pieces of information secret and treat them as confidential. And we've not had any issues. And they really do genuinely appreciate having as much information as possible to help them identify what goods that are coming in may or may not be counterfeit.
It's an excellent point, and thank you, Tamara, for the correction. That's correct. 2015 was the year in which the program was launched. I've also found that if you can make your materials flashy, easy to read, distill them down to a page or two, it certainly helps things. Chances are border officers don't have the time to leaf through a 50-page product ID guide, but if you can point out a few key features, things to look for on 1 or 2 pages, it makes enforcement a lot easier for the border officers of the CBSA.
Charts, arrows, and highlighting.
Colors too. With that, I'll turn it over to you, Tamara, to talk about some reactive strategies.
Thanks, Graham. And that was absolutely fantastic. I think that really sets some good groundwork for what we're going to talk about in the reactive strategies part of the webinar, because they do build off of a lot of the groundwork that you'll lay by adopting some of these proactive strategies. So like proactive strategies, reactive strategies tend to fall into 2 camps. Again, consumer-facing, public-facing, and then direct action against the wrongdoer. And I'll touch on these as we go through it. So some of the external reactive brand strategies, what are we talking about when we talk about reactive strategies? What happens when things go wrong, right? So you've done your proactive steps, you've recorded your rights, you've registered your rights, you've educated your consumers what proper goods and authentic goods look like, but now something's gone wrong. You're alerted to a bad actor. What can we do? Well, consider whether there are any consumer-facing steps that need to be taken. Are there any pressing consumer considerations? Is there a health and safety consideration? A number of months ago, there was a recall on some infant formula. So there was a consumer-facing campaign that needed to be done there. Or if you have a strong brand presence and you want to think about advising consumers specifically what is not an authorized channel or is an authorized channel. This can be done through press releases, notices on websites. It really is sort of the flip side to strategies you'll use when you engage with consumer education, right? Because this is a type of consumer education. But instead of educating consumers what is an authentic product, you are now educating consumers what is not an authentic product. Whenever you engage in this type of a reactive strategy, you want to make sure that you have a PR plan in mind and set down. You want to have a narrative, a designated spokesperson, talking points. You're really managing this crisis. So having a single point person to direct all comments to is going to be really important because, again, it's about controlling the narrative. It's presenting a single point of contact and a single narrative as to what is occurring. So now that we've taken care of the consumer things, what do we need to take care of on the back end if we want to set ourselves up well for taking action against the wrongdoer? Well, the first step is to gather evidence. Now, as lawyers, we always ask, well, what's the information? What facts are these based on? How can we guarantee the authenticity, the provenance of all of these facts that we're going to put in front of a judge or put in front of a decision maker? And so making sure that we're gathering evidence at an early stage before they have an opportunity to change is a really important piece of the puzzle, because that's going to form the basis for whether you're sending a demand letter or bringing an action or taking any other steps to address it. These are the photographs. This is the information that you're going to use going forward. You can do this in-house. You can engage with legal counsel who can assist. You can engage with a third-party investigator who might have expertise in these types of investigations and evidence gathering. Ooh. Sorry. Oh, no. Making sure we're on. Okay. Now we're on the correct slide.
Tell you.
The other piece is before taking action, making sure that your registered rights are up to date. If the issue involves copyright, making sure that the copyright, the title is clear to the work that you want to assert, ensuring that it's registered on the copyright register. While not mandatory to have to benefit from copyright protection, it can be very important from an evidentiary perspective. It's much easier to enforce when you've got a piece of paper to show someone than if you're simply relying on the rights that arise as a matter of statute. From a trademarks perspective, if you don't already have that trademark registered, strongly consider filing the trademark application before taking any other defensive steps. And that really is to ensure that your rights aren't usurped by the bad actor or by a third party. And then you're on the defensive on two fronts. If there is a concern about timing, the Trademarks Office does have the option of expedited examination. So filing your application, submitting an affidavit explaining why your trademark needs to be picked up faster than everyone else who's in the queue. We can absolutely help with preparing that type of evidence, that type of affidavit. We do it for many clients. And then once that paperwork is submitted with the Trademarks Office, it's usually a matter of weeks before it moves to first examination. So as Graham mentioned, at present, the Trademarks Office is taking about 8 months from filing to first examination. If all your ducks are lined up and you require expedited examination, you can get to first examination within a matter of weeks from filing.
And Tamara, I'll take this opportunity to add that one of the circumstances in which expedited examination is available is if you need your registered right to be recorded with the CBSA. If you're having trouble with counterfeit products coming into the country, or simply want to prevent such products from coming into the country, and you want to record your rights, you can state as much on your request for expedited examination, and that is one of the valid bases for obtaining expedited examination in a matter of weeks.
Thank you, Graham. That's a great point. That's absolutely right. So beyond registering your right, another option for taking direct action when problems arise is through intermediary or platform complaints. These are going to be adjudicated a lot faster than any litigation might be, and might actually achieve a broader result. If it works, it's fast and it's relatively cheap. And the process does vary from platform to platform. So when you're thinking about these types of reactive strategies, you want to think about whether you're going through, for example, a social media platform or a seller platform, or even a search platform. So thinking about, are we looking at a Facebook takedown, Instagram, TikTok, Amazon, eBay, and Graham, you touched on the Amazon brand registry before, so there are some proactive steps that can be taken there. Then on the search platforms, Google, Bing, Baidu, are there any steps? Are there any processes there? Compare that to the internet intermediaries like ISPs or the registrar, whether it's more appropriate to make a complaint there. The process is typically similar across these things, though with little changes between the various platforms. Most of them are based on the DMCA, the Digital Millennium Copyright Act, which is the legislation in the United States. And that's really seen as the gold standard for platforms, because that allows them to sort of put their hands up and say, we're a neutral intermediary. You've alerted us to this issue. We've taken it down. Please don't sue us. Canada's regime is a little more generous. We have what's called a notice and notice regime, wherein the complaint is submitted to the platform and then the complaint is passed on to the user that's the subject of the complaint without the requirement to take down. But because so many of these platforms are cross-border, they do use that higher standard that's required by the US legislation to avail themselves of that third-party defense. The process is usually a matter of filing a complaint with information about the right that's being asserted, about the right that's being infringed through the platform itself. And then it's evaluated by someone on the platform. And the outcome is typically one of three things. Either the request to take down the content is granted outright and the content is removed. Sometimes the platform will come back to you and ask for more information. This could happen oftentimes if there's an error in the trademark registration number, or the dates or the URLs that you're asserting has the infringing information on it. And then the third option is that the request is denied outright. Oftentimes before denying a request outright, the platform will ask for more information. And if they do deny it outright, oftentimes you can try to resubmit with the proper information. As Graham mentioned earlier in the presentation, for some platforms, you can pre-register your rights, and that can help automate some of this takedown process and reduce the load on the business or on the legal team, which is really good. On filing the complaint, many platforms will have drop-down menus that identify the category of the complaint. If it's a trademark complaint or a fraud complaint or a phishing complaint or a copyright complaint. And it's really important to make sure that you're submitting just one complaint. Like anyone you're working with, you're giving them too many instructions, too many directions at once, there'll be a little bit of confusion and they won't know which one to pick up first. So being really clear, being really focused, picking your best argument and advancing that one, even if there are multiple categories that could apply. So on this slide, I just have up some forms, that drop-down menu for TikTok and for Instagram, just so that you can see what these forms might look like. Now we're moving to a little bit, we've registered our rights, we've done what we can on the platforms. Now we're thinking about what are the quasi-legal processes that we can engage in. If there's a domain name that's an issue online, we can consider a CDRP or a UDRP proceeding for those disputes. Those apply where the mark itself has goodwill in Canada, or if you're not a Canadian entity, you have a trademark registration for that mark. If you're going through if what you're trying to do is address a .ca issue, and it's for domain names where they're really registered in bad faith and without legitimate interest. These types of proceedings really are quite narrow. There are arbitration proceedings set up by the registrars in Canada. It's CIRA, Canadian Internet Registration Authority. Internationally for the .coms, the .orgs. This tends to be through ICANN, and they've designated certain entities throughout the world as being arbitrators. It can be not a lengthy process, but a bit of a burdensome process, because in preparing the complaint to file, all of the evidence, all of the argument needs to be presented up front as part of the submission. And then the result itself is quite narrow. It doesn't actually stop the use of the mark, but if successful, it will result in the domain name being transferred to you. And then, of course, there's a decision that needs to be made within the business, whether the business wants to keep renewing that registration or let it go back out onto the open market. From a Canadian register standpoint, a lot of brand owners will, as Graham mentioned, put watches on the trademarks register to see what marks are being filed, applied for, and then considering whether to oppose if those marks of concern are advertised. And then if those marks of concern are discovered after registration, considering whether they might be vulnerable to non-use cancellation proceedings to try to keep the register clear. Both of these are inter-parties administrative proceedings. Oppositions are sort of what I like to call litigation light, because they do require a training of pleadings. There's evidence. There's cross-examination that's available on the evidence, and then the written and oral submissions, and the decisions of the registrar and oppositions are appealable all the way up to the Supreme Court if you have leave granted. So these can be very powerful tools, but again, they do have quite limited effect. They're really just speaking to the ability of this mark to be registered or to be maintained on the register. So thinking about the limitations and the purposes of these quasi-legal actions is really important before engaging with them. And then, of course, you can always pull out the big guns, and we go, full out litigation. So one of the first steps whenever thinking about litigation is establishing what the rights holders' rights are. So through demand letters, the benefits of these are that they set out the rights holders' rights, what the other side's infringing conduct is. There's a threat and requirement for action, and oftentimes these can be really scary to receive. And the receiving party will either comply or at least negotiate for a settlement or for a bit of a sell-off period if it's an infringing as opposed to a true counterfeit product. The challenge with this, though, is that if it really is a bad actor on the other side, they can take steps to hide their identity. And of course, you need to be able to identify who the receiving party is before sending a demand letter or launching a litigation. So it can be difficult to identify who those people are. And conversely, it might just be ignored. So as scary as it is to receive a demand letter, if the bad actor is truly intent on being a bad actor, they might simply ignore it and sort of stare the rights holder down and go, okay, sue me. And so then the question is, do we sue? When moving into litigation, the things that we want to think about are, this is really a last resort. It can be expensive. The ending can oftentimes be uncertain, especially if it's two sophisticated parties that are across the table from each other. When considering where to launch or whether to launch, thinking about jurisdiction or form, Graham and I in our practice think about whether federal court versus provincial court is more appropriate, because both have their benefits and their drawbacks. Also thinking about what rights are being asserted can impact questions of jurisdiction and form. So if we're relying simply on common law rights, perhaps a provincial claim would be better than a federal claim. If we're involving registered trademarks, there is some expertise before the federal court. Another question is, are there any interlocutory steps that need to be taken? And that might affect jurisdiction and form and what choices there are. So thinking about whether in the early stages of litigation, an interlocutory injunction might be necessary, and the challenges around that, considering whether there need to be any Norwich orders to identify who is behind the actions, whether a Moreva injunction is needed to freeze assets before judgment, because oftentimes if you are dealing with a bad actor, they'll try to shift around their assets. So having that type of order in place can be a really powerful thing to ensure that at least there's some compensation on the back end when the rights holder is successful. And to the flip side to that is considering whether an Anton Pillar order might be necessary to attempt to seize the evidence before it is destroyed. These are really extraordinary remedies and extraordinary measures that a court can grant the claimant to take, but they can be quite difficult. So rights holders need to be very conscious and careful in both preparing the evidence and making the claims when seeking this. Yes, go ahead, Graham.
Just very quickly, you mentioned demand letters and the benefits of demand letters. They clearly set out the brand owner's rights, but they also set out the recipient's obligations, including litigation hold obligations, which come into play when litigation is being contemplated. So the recipient is required to retain all documentation, all evidence that may be related to the claim against them. And it's an excellent way to put them on notice. And that might come into play later on if you take those further steps towards litigation. It also puts the bad actor on notice, and in some cases can unlock additional causes of action, such as knowing copyright infringement or secondary infringement under the Copyright Act. And so there's certainly benefits to putting your rights on paper and sending those letters to bad actors, even if you're not ultimately going to go all the way to a trademark infringement action or a copyright infringement action. Those letters are important for setting the stage and affording you every option available to you if you choose to go down that road.
Thank you, Graham. Those are absolutely correct. And then getting back to thinking about litigation steps also and whether or not to launch is practically on the enforcement side. So a lot of rights holders will ask, okay, my trademark's been infringed. How much damages can I get? And especially those who work cross-border in the United States, if there's really a bad actor on the other side, there are statutory damages for trademark infringement, there are treble damages. So the judgments can be quite high. As opposed to in Canada, where from a damages perspective, the damages on the whole tend to be quite low, and the more important remedy tends to be the injunction. Other steps that might be considered when taking reactive strategy is working with law enforcement. Now, of course, the drawback here is that once the information is given to, whether you're working with police, Health Canada, RCMP, they will start their own investigative procedure. And while they might reach out to the rights holder in the course of that investigation to gather more information, the rights holder really gets locked out and doesn't have information as to how the investigation is going or what steps law enforcement might be taking. Typically, we see this done if there is a health and safety issue or if there's an organized crime issue. So drugs, gangs, and guns. But it really is sort of, it's more of a long-term reactive prospect because it's a matter of building relationships with people within this department. Another option is reporting to the Canada Anti-Fraud Centre if what's being encountered either online or in the real world is truly fraud. And as mentioned, the challenges with using this type of reactive strategy is that the process really is beyond the rights holder's controls. So Graham and I have sort of laid out all of these tools on the table now, all of your proactive tools, all of your reactive tools. And so the question then is, well, what do we do with these tools? And it really is, it becomes a matter of turning all of these strategies into action. And how do we do that? Well, before we talked about register, register, register. Now we're talking about plan, plan, plan. So up on this slide is some points to think about when developing a plan and then implementing it. So it really is a matter of three things. It's developing what you could do and then sticking to it. Sometimes it can be difficult when you're getting a lot of information, a lot of different input from different departments or from different stakeholders, but really being clear in what the plan is and sticking to that plan can be quite important. It does help with budgeting and resources. It avoids over enforcement. It helps manage any PR, and you're thinking about it at a point in time when your head is a little bit cooler than when you're in the heat of the moment. But of course, you always do need to adjust the plan if things happen.
And it's important to note, Tamara, that it's not a one-size-fits-all solution. Your plan will depend on your goods and services, your customers, your target market, the jurisdictions in which you do business, and the way you commercialize your products. And so it's important to work both with in-house legal, external legal, to develop a bespoke plan that works for you and your business. I've prepared a few decision trees myself for clients, and I found those to be very helpful. In that, say there's a seizure of suspected counterfeit goods at the border. If it's under a certain amount, no action's taken. If it's over a certain amount, a certain step is taken. If it's over a higher threshold, then the client takes an even greater step. And if it's the case of a bad actor, recidivist, someone who they've dealt with before, they might go even one step further. And so, depending on the nature of the infringement, they know how to go about addressing the problem. And it actually makes for a much faster reaction to such infringements. You spend less time hemming and hawing about what it is we should be doing. You look at comparable cases, you look at what you've done in the past in similar circumstances, and that can help inform what to do going forward.
So on this slide, I think, Graham, it really reflects well what you just mentioned. Thinking about what the nature of the harm is, what kind of wrong is this? What path should I be choosing? Is there potential backlash? What are the risks, and how do I manage those risks? Are we dealing with a large sophisticated seller, someone who's a recidivist, or someone who's relatively new, small, and maybe, wasn't aware? I like to give people the benefit of the doubt, but maybe they weren't aware what they were buying was counterfeit. And at the same time, also thinking about cost. Right. So we mentioned budget earlier, and cost, is really important. If you're part of an in-house legal team, trying to justify your budget to the business is a really important part of it. So having a plan in place can really help identify where costs can be best and most effectively used. And then also urgency. How fast does this need to be dealt with? Obviously, when a wrong is discovered at field, there's a need to, it feels like there's a need to take care of this fast. And obviously there are limitation periods that we want to be aware of, that we're working within. But it is just as important to make sure that we have the correct pieces of evidence and all the facts and all the information gathered, and having a plan in place that enables you to slot in what steps need to be taken can really help address situations where there's a little bit of urgency.
And some of the factors you talked about earlier, concerns about health and safety, reputational damage, these are drivers of urgency. These are things that will make a particular issue more important, more pressing than something that might not, see much sunlight. And so it's important to think about the consumer blowback or ramifications that may come of an infringing action that you've uncovered.
And so here we have, Graham, I think some of what you touched on earlier about border enforcement and online enforcement, specifically things to think about when developing a plan to address wrongs that we're seeing, that you're seeing online. Obviously, it's going to be different for every rights holder. It's going to be different for every business. But these are sort of broader questions or broader strategies that can be considered to help address the various considerations that we flagged earlier on in the presentation. With that, Graham, should we move on to any questions?
Sure. So I see we have a question relating to the DMCA. One guest writes, do you have any thoughts on the future efficacy of DMCA takedown requests following the U.S. Supreme Court's decision in Cox versus Sony? Now, I have not read the decision myself, but if you have, Tamara, I'll let you have at it. But perhaps we can get back to the guest offline with our thoughts.
I've not read the decision, but my understanding is that really has it really was a very specific provision with respect to third-party liability in sort of flow through information. It didn't really touch on the DMCA. It touched on a different piece of legislation. And so the DMCA is still in place, it's still valid. And I don't see it moving the dial terribly much with respect to online enforcement through that method. Whether it changes the way that litigators think about vicarious liability and the responsibility of third-party ISPs, certainly there's an evolution there. But again, this is a US decision. So to the extent that it's affecting things in Canada, that's yet to be seen.
You had mentioned earlier that our own online takedown program, the Notice and Notice program, has a bit less teeth than the DMCA.
I see that there's another question. Graham, we mentioned writing demand letters and the bad party can ignore, thereby hiding their identity. If suing is the next best option here, how do you identify who to sue and what are the long-term pros and cons to this choice of action? So that really, Graham, do you want to take
Sure.
this one? Okay.
Sure. So I found that a thorough corporate investigation in advance of a demand letter can assist greatly in identifying the right person. Occasionally, it's not just one person. Occasionally, it's a small network of related companies that are involved. There might be a manufacturer, exporter, importer. And so we've often used third-party investigative services that can help track down the companies and the individuals behind those companies, access residential addresses. And so we know where exactly they are and how to get to them.
And sometimes the process that you're engaging with will allow you to obtain the bad actor's identity. So, for example, through CBSA border enforcement, the first step is CBSA will alert the rights holder to the detention and usually provide them with photographs of the detained goods to ask if they want to take further action. Once the rights holder decides they do want to take further action, CBSA will then provide the identity and address and contact information for the importer. Similarly, when commencing a UDRP or a CDRP, the identity of the registrant, even if it's shielded in the WHOIS, will eventually be disclosed as part of that proceeding. For something like online enforcement through platforms, the actual identity, if you're just looking to stop the precise wrong that's occurring online as opposed to try to gather more information, the identity is a little less important. As long as you're able to identify the username or the URL where the where the problematic content is being hosted. And then, of course, in litigation, there are procedures that can be used. A tool that is often used in copyright litigation is a Norwich order. And of course, making sure that the test for obtaining that type of relief is met is a really important part of the litigation strategy.
We have a further question about DMCA takedowns, a hot topic today. With the DMC takedown, how do you protect your clients from bad actors requesting takedowns?
That's a good question. So most platforms will have a way to contest a takedown. So frequently the way that the procedure works is a complaint is filed, the matter is taken down, and then the entity that was the subject of the takedown has an opportunity to respond and convince the platform to put things back up. If it's a legitimate product, or it's very clearly the right holder's account, or the right holder's content being posted by the rights holder, it's a little more difficult for a bad actor to use that procedure to frustrate the genuine rights holder. It's not to say that it isn't done, and sometimes these platforms do make mistakes. But for the most part, and especially if you have your rights registered with the platform, so through an Amazon brand registry or Meta's brand registry, it can frustrate those types of attempts. But I commend the creative thinking of how bad actors can be even worse actors.
Looks like we have time for one more question.
Hmm.
What's changed most in the past few years when it comes to protecting brands at the border and online? One thing I've found over the last several years is thankfully a greater awareness of these issues among brand owners. As I mentioned, counterfeiting is industry agnostic, and brand owners are beginning to realize that counterfeiting, infringement, piracy, it's every brand owner's problem, and it's not exclusive to one industry or another. And that is greater awareness has, I think, helped drive a business need for more tools, more enforcement, more proactive and reactive strategies to combat such evils.
Graham, I absolutely agree with everything you've said. And I think it really is a ripe time for rights holders to begin building these awareness and these tools and these strategies, because we are seeing, as I mentioned at the beginning of the presentation, we are seeing AI add fuel to the fire. Because of course the internet is everywhere and the internet is international. And as a consequence, the discoverability of your brand, your products is likewise international. And the ability to produce counterfeit or non-legitimate goods is becoming faster. Communication is faster, production times are faster, our production abilities are faster. It's easier than ever before to produce a good. And so what we're really seeing is the combination of that acceleration with brand owners waking up to the fact that counterfeit is an industry agnostic problem, is really moving things a lot faster and is bringing a lot more of these issues to the light, which of course is good because it helps us control our narratives, and protect the brand, protect its reputation and its goodwill.
Nicely said. Well, thank you very much, Tamara. With that, I think we've reached the end of our Q&A session. Thank you all so much for joining us today, your participation, your insightful questions. As a reminder, when the webinar ends, a survey link will pop up on your screen. We'd greatly appreciate it if you take a few moments to share your feedback with us. Thank you all very much.
Thank you. Have a great afternoon.